Hello, welcome back. This is Subathra Mylsamy, partner at AK Mylsamy and Associates. So I hope all of you would have had a wonderful Diwali celebration. And today's topic is going to be on the law of wills, which is extremely important, and I think everybody should know about it. I hope this video will be beneficial with whatever information I'm going to give it to you all. So everyone is always anxious about what will happen to their possessions after the death, and they also want to ensure that their properties are being distributed either to their legal heirs or to anybody else according to their wishes. So if you look into through a will, a person can generally specify how and to whom his or her property should pass after their death. So it is always preferable to make a will to ensure that one's actual intentions are followed and the property is being distributed in accordance with their wishes. So if a person passes away, say for example, without writing any kind of will, generally then the property is distributed through an intestate succession where there is a separate law which governs, especially under the Hindu Succession Act. And for the other religions like for Muslims and for Christianity, there are specific laws which govern according to their religion. Now let us dive into the basics. So first thing is, what is a will? Now, under the Indian Succession Act, a will is clearly defined as a legal declaration which captures the intention of the person with respect to his or her property, which he or she desires to take effect after their death, which is basically how you want to distribute your property to your legal heirs or to anybody else according to your wishes. Next thing is the most important thing, who is eligible to make a will? So the basic thing is any person who is of a sound mind and is a major is entitled to make a will, as well as an ordinarily insane person. That is, sometimes people are in for a particular time of period, they may be insane and then they may come back to sanity. Even those people are allowed to make their will. And also a deaf and dumb person can make their will only if he or she can understand the meaning and purpose of the will. So the person who is generally making the will is called as a testator. Now let us see who are the people not eligible to make the will. So any person who does not have any sound mental health which is caused by either illness or intoxication or any other things cannot make a will. And also a minor who has not completed the age of 18 is not capable of making any will. Now next is the most important part in writing the will, which is what are the ingredients in writing a perfect will. So first you should have the testator details, which is nothing but the person who is making the will, the details of them have to be complete. And the legal declaration, which is nothing but in how the property is going to be disposed, to whom, to what property is being given or disposed to them. And also the intention of the testator. So sometimes they can also write a conditioned will where the person who's writing the will can place a condition saying if so and so gets married, only then the property will be given to them. Or there will be a conditions generally by parents saying that my children have to take care of me or pay me a monthly sum of so much, then only so and so this property will be given to them or handed over to them. So that is also a conditional will is possible. And also it should be made only with respect of his or own properties, not anybody else's property. And also the beneficiary details have to be very clearly listed out to whom the property will be given to. And also what are the desires to be carried into effect after his or her death. Sometimes testators also write how after their death the bodies have to be disposed or certain last rites have to be conducted. So that is also can be captured in the will. And the executor of the will. So any person can be executor of the will. It's not required that a lawyer has to be an executor. But one important aspect is no beneficiary can be an executor of the will. And also for any guardians have to be appointed for minors. If property is being disposed of to a minor, guardians have to be appointed for that. Signature and dates are extremely important in the will, as well as the description of the properties. With clear description is extremely important. And also most important aspect is if there is going to be any denial of the properties to any of the natural heirs, that has to be clearly mentioned. So all these things are essentially important to make a very good will. Plus another important point is 2 witnesses have to be present when execution of the will. Next is what are the conditions for making a valid will? So a will can be made in a plain paper. A stamped paper is not a requirement. And the testator should sign or affix his thumb mark and must be attested by 2 or more witnesses. And these witnesses must have seen the testator sign or affix the thumb mark on the will, or should have received an acknowledgement from the testator that he has signed this will. Now each of the witnesses shall sign the will in the presence of the testator only, and the witness should not be a beneficiary under the will. That is very, very important. The witness can also be appointed as an executor under the will. Next is what are void wills? A lot of people have a doubt on this. So a will or any part of a will which is being made by any kind of fraud or coercion is called as a void will. And a will which is not expressive of any definite intention and it is very uncertain, then it becomes also void. And a will which comes to effect on fulfillment of a condition that is either immoral and it is illegal also is void. Next is about revocation or alteration of the will. So a will can be revoked or altered by the maker of the will at any time when he is competent to dispose of his property by will, which clearly says that he has to be of insanity even when they do any kind of alterations. So revocation can be done by the execution of a subsequent will or by writing a declaration with an intention to withdraw the will. Next is on the alteration of the will. So if a testator, if he intends to make a few changes to the will without changing the entire will, he can do so by making a codicil to the will. Codicil is nothing but it is also a document which is executed in a similar way as the will. So it is an instrument which is made in relation to a will explaining, altering or making any kind of addition to its dispositions, and it is deemed to be part of the will. Next is on the notarization and registration of the wills. Now, notarization by the notary public or attestation by an oath commissioner is generally not required, and registration is also not compulsory for the wills. But it is always advisable to get the wills registered. So if it gets registered, then the transmission of the properties becomes very easy. Plus, there is also a higher authenticity is attached to the will, and a will can be registered at the office of a sub-register. The personal appearance of the testator before the government official with the original will also adds to the reliability and trustworthiness of the will. So a registered will always provides a strong and a legal evidence against any kind of challenges which is being made about the mental capacity of the testator while making the will. The most important part now we come is on the execution of the will. So a will is executable only after the death of the testator. So it is not necessary to obtain a probate to execute the will if there is no dispute regarding the will. Now going through a probate is preferable as it gives a court certification to the validity of the will if it is in question. Probate is nothing but it means the copy of a will is certified under the seal of a court. So in order to obtain the probate following the death of the testator, the executor of the will or a legal heir of the deceased testator may file a petition before the court of any original jurisdiction or the High Court. So the probate of a will generally removes all the complications which may arise on the property distribution after the death of the executor. Probate is regarded as a conclusive evidence of the genuineness of a will, and the other heirs of the deceased testator will be questioned also by the court to see whether they have any objections to the will as such, and the court may also grant the probate if the validity of the will is very well established before the court with supporting evidence. If the will is extremely clear, then this whole process of the probate can be avoided. To sum up, I would like to tell that before execution of any will, please have a clarity on how you're going to dispose of your properties to your immediate family members. Maybe it is your legal heirs or anybody else. Ensure all the ingredients of the will is being captured very well with the executor as well as with two witnesses on hand. Plus, you need to always remember that at any point of time you can cancel your will, or else you can make changes or make additions to the will by a form of the codicil. So please keep these things in mind and execute your will with careful planning and thought. I hope this video would have been informative for you all. Thank you so much for watching. See you next time. Bye.